All right. Good morning, everyone. My name is Richard Ponte, and I'm the Director of Events and Programs for the Maine State Chamber of Commerce. On behalf of the entire team here, it is my pleasure to welcome you to Paid Family and Medical Leave, Final Rules Breakdown, and what you need to know for January 1st, the latest in our webinar series. Thank you for joining. Before we get going, there are just a few things we'd like to share with you about today's session. If not presenting, please turn off video. To reduce background noise, all participants will stay in listen-only mode. Please stay on mute to reduce noise. You can submit questions into the chat panel addressed to everyone. Time permitting, we will answer them by the end of the session. We will use the chat function as well to share useful links and other materials. And the meeting is being recorded, and we will make the recording available to you on our website in the next few days. And finally, if you lose your connection, please use the same Zoom link to reconnect. We would now like to begin by thanking our sponsors. Our exclusive premier sponsor is Cross Insurance. Our corporate sponsor is Littler Mendelson. And our 2024 webinar series sponsors are AARP, Central Maine Power, Northeast Delta Dental, Kennebec Savings Bank, and Sun Life Insurance. Again, many thanks to all of our sponsors this morning. It is now my pleasure to introduce Jacob LaChance, who is a government relations specialist with the Maine State Chamber of Commerce. Jacob will be leading and facilitating the conversation today. Good morning, Jake.
Good morning, Richard. Thank you very much for that introduction, and thank you again to all of our sponsors for this event. Really want to thank everybody for tuning in on this pre-holiday Friday here to talk about what employers need to know for the Maine paid family and medical leave. Obviously, the rules have been finalized from the Maine Department of Labor last week, and really diving into what employers need to know and preparing for January 1 and beforehand. It's really important that we continue to get the word out as we've been kind of doing all summer and beforehand. With me today from Littler is Mindy Caterin and Ellen Donovan McCann. These should be familiar faces to you at this point when talking paid family medical leave about the chamber. Their expertise is really second to none, and we're very fortunate to have them as a part of kind of the chamber contingency for these paid family medical leave webinar updates. So with that, I will turn it over to Mindy and Ellen. Really appreciate you being with us this morning.
Good morning. Thank you for joining us today. Ellen and I are management side employment lawyers at Littler Mendelson. I'm on the board of directors of the Maine State Chamber of Commerce, and I'm the chair of the HR committee. And Ellen is a national paid FMLA expert. She was in-house for most of her career, and last year she joined us at Littler. We're very, very fortunate to have her. Ellen and I worked together on the comments for both rounds of the Maine paid family and medical leave rules. So we've been deep in the weeds. So Littler, just a quick plug for Littler. We are a national labor employment firm. We only do labor and employment on behalf of management. Next slide is good, Jake. Today, we're going to discuss the nuts and bolts of Maine's new paid family and medical leave program. As I'm sure you're all aware, the final Maine PFMLA rules were released last week, so there's not a lot of new information. We're going to try to cover as much information today as possible, including what is paid family medical leave, who is covered, when do employees get to take leave and for how long, how does this impact employers, and how are we going to make it all work? I'm sure you're all asking yourself just exactly that question. We'll leave some time at the end for questions, so feel free to put your questions in the chat, and we'll get to them at the end. And if we don't get to them all, we can follow up with you, or you can follow up with us if you have questions following the program. We are easy to find. In July of 2023, Maine joined about a dozen other states with paid family medical leave programs. Maine's program is one of the broadest and most generous in the country, so we're very fortunate. PFML provides employees with up to 12 weeks of paid leave per year. And as a result, nearly every employee in Maine, including self-employed individuals, will be able to participate in the program. Leave is available for a very broad range of reasons, including for the serious health condition of the employee or a family member, the birth, adoption, or placement of a child in foster care, safe leave for victims of assault, sexual assault, or stalking, and family military leave. So quite an array of reasons that somebody could take paid family medical leave. And beginning in January of 2025, which is right around the corner, premiums equal to 1% of an employee's wages must be remitted to the Maine DOL. These contributions are split evenly between the employer and the employee. Employers with fewer than 15 employees are exempt from the employer portion of the premium, but they are still responsible for deducting the 0.5% from the employee's wages and remitting those deductions to the Maine DOL. Next slide, please. And this next slide, this is a graphic that comes directly from the Maine DOL. During the first 2 rounds of rulemaking, there were approximately 1,600 comments. The DOL issued a 127-page report with comments and responses to those comments. It's quite long, but it's worth a read. It has a lot of information in there that you might not expect is there, but there are some hidden gems, so it's worth a dig through. Payroll withholdings will start on January 1 of 2025, and benefits will be available starting on May 1 of 2026. Go to the next slide. So who's eligible? With a few noted exceptions at the bottom of this slide, almost everyone who earns the requisite amount of wages in Maine is eligible for the paid family medical leave. Employees can take leave immediately upon hire, so long as they've accumulated enough of the wages during their working period. And employees in some situations can apply for benefits following termination. And so, for example, if somebody started a leave, even if they didn't apply for paid family medical leave, if they're on a leave for whatever reason and are terminated, there's the potential that they could still apply for those benefits during that 90-day window. So there is that possibility that somebody could actually apply for benefits after they've been terminated. So we'll have to see how that works out. And then we'll go to the next slide, Jake. Employee notice. Notice that the need for leave must be in writing, but it can be a text or an email. There's no special form that's required. So employers need to make sure that their supervisors understand that if they received a text or an email from an employee about the need for paid family medical leave, that they give that information to the appropriate person, most likely somebody in HR. So your line employees, line supervisors, they need to understand that if they get a notice like that, a text, an email, any form of written communication requesting or notifying the employer of the need for paid family medical leave, that needs to go up the chain to HR. And under the rules, 30 days written notice is presumed to be reasonable notice. And in the case of an emergency, the employee must make a good faith effort to provide written notice as soon as feasible. So they might not be able to do it as promptly as you would want, but as long as it's feasible. If an employee is incapacitated, then the notice can be provided by a family member or by the employee's healthcare provider. So it does not have to come directly from the employee. So the employee notice must include the reason for leave being requested. For example, is it family medical leave? Is it safe leave? Is it military leave, family military leave? The type of leave that's needed, continuous, reduced schedule, intermittent leave. The actual or anticipated timing and duration of the leave, and any other relevant details regarding the employee's need to take the leave. We can move on to the next slide. And I am going to turn it over to Ellen.
Yes, I think we're there. Hi, everyone. Nice to be here with you today. I will tell you, hopefully you can all hear me okay. My external speaker went out as we started talking, so that happens in almost every webinar. We can expect some kind of technology difficult, and that is mine today. So if you can't hear me, although I am been told I'm very loud and usually people have no problem hearing me no matter what the setting is, please just let me know. So I'll continue with my computer speakers. So the next slide we've called important information for employers. Actually, obviously the entire deck is important information for employers, and we could go on for hours about important information, but there are some things we really wanted to highlight here for employers, particularly since we know there are a lot of employers in Maine who are not large enough to be covered under FMLA. So this whole concept of job protection is likely new for you. And even for those of you who are covered under FMLA and you're used to job protection, you may be wondering, I know Maine PFML provides money to my employees when they're out, but do I also have to hold their job? Do I have to protect that? And job protection or reinstatement is provided under Maine PFML for employees who have at least 120 days tenure with the employer. And so the reinstatement, for those of you who are covered under FMLA, it's very similar to FMLA, meaning the employee, when they're done with leave, they're entitled to be reinstated to their same job or an equivalent job. The equivalent job has to have equivalent pay, benefits, and terms and conditions of employment. So it is a pretty strict standard, very similar to FMLA. However, one thing is that a lot of employers haven't realized about Maine PFML is your obligations to employees do not end there with job reinstatement, because there is a very broad anti-retaliation provision in the law. And that anti-retaliation provision does not specifically apply only to employees with 120 days of tenure. So the way I interpret this is all employees who've taken Maine PFML are entitled to be free from retaliation. How that works with an employee is going to be interesting, I think, as we see how the program goes. Because just as one example, retaliation is defined in the statute as the application of an attendance policy to an employee who's taken Maine PFML. So you want to work with your counsel on this issue, because although you may not have to reinstate someone who hasn't been with you for 120 days, you will still need to be careful about how you document and potentially performance manage those absences that they may have taken while they were on Maine PFML. So that's something you want to be really careful about and may catch some employers off guard. As a general matter, Maine PFML will run concurrently with FMLA, and this is good news, right? Because we like to have all of the leave protections run at the same time. We want to avoid employees being able to stack leaves. And that is clear that Maine PFML will run concurrently with either federal FMLA, or if you're not covered under federal FMLA, will run concurrently with Maine FMLA as well. But be careful that that will only happen if the leave reasons are covered under all of the laws and the employee is actually eligible under all of the laws. So just one quick example I'll give you is that Maine PFML covers a lot more family reasons than the federal FMLA. So there may be times where there is a little bit of a loophole to this concurrency rule, because your employees are taking Maine PFML to care for a family member who is not eligible for FMLA, and you will not be able to go ahead and designate FMLA to run concurrently. But for most of the leave reasons, there is some synergy between the laws, and you will be able to run those leaves concurrently. That means that your employees, for instance, can't decide to go out on an unpaid FMLA leave or Maine FMLA leave and save their main PFML entitlement for later in the year for that same reason, the time they took leave for FMLA or main FMLA will go ahead and come out of that entitlement, which is, it's good news for employers. The next slide, let's talk about the kind of leave employees can take. And Mindy mentioned this just briefly at the beginning. Similar to FMLA, for those of you who are familiar, employees have a choice of how they take their leave. They can take it all at one time, or they can take it in various increments or blocks of time as they need it. Unlike FMLA, the intermittent leave and reduced schedule leave can be taken for any PFML qualifying reason. So under FMLA, you can limit bonding leave, for instance, to continuous leave. You do not have the ability to do that under main PFML. Employees can take intermittent leave for any of the leave reasons, and they can take reduced schedule leave for any of the reasons. But one interesting thing about main PFML is employees have to take the time in full day increments. They can take it in less than full day increments, but only if their employer agrees. And in no event can the increment be less than 1 hour. So if you're thinking about reduced schedule leave, this might look a little bit different than what you're used to in other contexts, because reduced schedule leave is often someone working less hours per day for a certain period of time. Unless an employer waives that full day increment leave, reduced schedule leave under main PFML will be someone taking less days or someone working less days during a week versus working less hours during the week. Let's move on now to the reasons for leave. Mindy mentioned these quickly at the beginning, but on the next slide, we want to talk a little bit more about what they are. Here again, a lot of this aligns with both FMLA and main FMLA reasons already, but there are a couple of nuances where things may be different. Generally speaking, family leave is covered. Family leave will include bonding and care for a newly born, placed child, and that's placed for adoption or foster care with the employee. It also will cover care of a family member or a loved one who has a serious health condition. Then the employee can take medical leave. And medical leave really is when the employee has a serious health condition that prevents them from performing their job. They can't just have any old medical condition. It actually has to result in incapacity that prevents them from doing their job. Safe leave is also covered, and this is really broadly defined. It's any time an employee needs to take time away from work, either because they or any of those qualifying family members is a victim of violence, sexual assault, or a variety of other types of violence that the statute defines. And these can be absences for things ranging from an employee who needs to seek new housing to be safe, or they need medical attention, or they need to go and seek the help of the court system to get a protective order. So it's a very, very broad category of leave. And again, remember, it's not just if the employee is the victim, but it's also if their family member is the victim and the employee needs to go ahead and help them with those activities. The last two reasons here that I'll talk about are what we call family military amendments. Important to note, if you're new to this, that these are not reasons when the employee is in active duty or is a member of the United States or main military. This is when their family member is a member of the military. And there's some reason why the employee needs to be absent from work due to that family member's service. So the first category is active duty or qualifying exigency leave. It's a really fancy lawyer term, right? Qualifying exigency, which basically just means there's some event or emergency that covered service member needs to attend to, and the family member has to have that event. And so the employee gets to take time off from work to help or to attend some of those events. And then finally, military caregiver leave is when the employee's family member was injured in the line of duty and the employee needs to take time off to care for them. Unlike FMLA, for those of you who are covered, family military caregiver leave is still a 12-week entitlement. It is not a 26-week entitlement like we're used to in some of the other laws. And so, as Mindy mentioned in the beginning, even though we have several different leave reasons under Maine PFML, the combined leave taken in a year is limited to 12 weeks. So if someone needs leave for a variety of reasons, they do not get 12 weeks for each reason in a benefit year. They get 12 weeks combined in a benefit year. And just a reminder, the benefit year starts on the Sunday before the employee starts taking leave and runs for 12 months rolling forward. Okay. On the next slide, let's talk a little bit more about some of the terms I've just been using for you. So some covered family members, and as well as, what is a serious health condition. So employees can take leave either if they have a serious health condition or if their covered family member has a serious health condition as well. And a serious health condition is defined similar to FMLA, but not exactly the same. And it's, again, pretty broadly defined. Any illness, injury, or impairment, and there's some other qualifications you can see there on the slide, that either involves a stay overnight in the hospital or continuing treatment with a healthcare provider in continued incapacity, meaning the employee cannot perform their job while they have that serious health condition. On the next slide, we'll talk about family members kind of in general. In really what the one family member that may catch folks a little bit off guard. So mentioned earlier, family member, much more broad than FMLA. We're going to be seeing coverage of parents, children, spouses, domestic partners, grandparents, grandchildren, and siblings. And by the way, in-laws of all of those relationships are also covered, which is unique and different from FMLA. But the other thing that's unique and different from FMLA is that employees can take leave to care for someone with whom they have a significant personal bond. For those of you who have employees in other states, you recognize this is really a trend in the paid family and medical leave programs across the country. It's a way to recognize folks who have kind of non-traditional relationships with people who are equivalent to a family relationship. So someone who I may not be related to biologically, I might not have a legal relationship to, but my relationship with them is the equivalent of a family relationship. And so in Maine, people can take leave under PFML to care for those folks who they have an equivalent family relationship to. Note that they can take this for more than one equivalent relationship in a benefit year, and that's a change from some of the prior regulations. The employer can ask the employee, and the state will ask the employee to identify how this equivalent family relationship works. There's a list of factors you can see on the screen, so I won't read them all. But what's important to note is not one of these factors is determinative. So the employee doesn't have to show all of them. They just have to show enough that when we're looking at this as a whole, there is an equivalent family relationship. So things like financial relationships, do they live together? Is there an expectation of care because that person has this close relationship? So when you're looking at equivalent relationships, the people do not have to live together. So it could be college roommates. It could be other folks. Mindy, you and I, we went to law school together. We've been friends, I won't say how many decades because I don't want to age us, but we've been friends for a long time. And we may be able to show that we have equivalent family relationships under this law because of our longstanding relationship there. So employers really just need to be aware that it really is a pretty broad definition of covered family members or loved ones for whom employees can take leave. So I'm going to turn it over to Mindy now to talk a little bit about undue hardship and some of the other concepts in the law.
Thank you. So undue hardship is a term that many of you are familiar with from the ADA, but it's a little bit different here. If the timing and duration of a requested leave creates an undue hardship for the employer may, in certain limited circumstances, be able to require the employee to take leave on a different schedule. And I expect this to be the exception and not the rule, but it is in the statute and in the regulation. So there is the opportunity to demonstrate an undue hardship. An undue hardship means a significant impact on the operation of the business or significant expenses concerning the financial resources of the employer, the size of the workforce, and the nature of the industry. So all of those things will be taken into consideration when determining whether or not the employee's absence from work for whatever period of time creates an undue hardship for the employer. Importantly, employers must provide a written explanation to employees of the undue hardship. So once an employee requests paid family and medical leave and the employer determines that their absence from work is going to create an undue hardship for the employer needs to be able to articulate the reason for that undue hardship, and they need to provide a written explanation to the employee. And there is no specific timeline set forth in the regulations for that, but I would suggest that you do it as quickly as possible, since what's going to happen is as soon as the employee applies for paid family medical leave, the Department of Labor is going to be contacting the employer, and the employer is going to have to provide that information. So you want to get ahead of that. See the picture next. Under the rules, an employer's determination of undue hardship will be considered reasonable if the employer provided a written explanation of the undue hardship to the employee. So it's important to do it right away and get it right out there. The employee can take leave within a reasonable period of time, either before or after the requested leave, which, quite frankly, may not be possible in certain situations. And third, the employer must make a good faith attempt to offer an alternative leave schedule that meets the needs of the employee and is not unduly disruptive to the employer. So, a lot of moving parts there. So if an employee believes that if the employer believes that the employee's leave of absence is going to create an undue hardship, you've got to look at these factors and take all that into consideration when you're making that determination. I also want to point out that the employee's healthcare provider can override the employer's decision if that healthcare provider determines that the employer's proposed schedule fails to meet the healthcare needs of the employee. So essentially, the employee's healthcare provider holds the trump card. So even if it does in fact create an undue hardship for the employer, if the healthcare provider says it's simply not going to work for the employee, then my expectation is that the Department of Labor is going to allow the employee to take that leave of absence. And as noted on the slide, the administrator can certainly overrule the employer's finding of undue hardship. Okay, so who pays for this leave? And that really depends on the number of employees that an employer has. As mentioned earlier, it's up to the employer to determine whether or not it's going to cover the 0.5% payroll deduction for its employees. However, it is the employer's responsibility to remit the premiums to the state, regardless of whether the employer pays the entire premium or whether the employer deducts a portion of the premium from the employee's paycheck. An employer's decision about deducting premiums from an employee's wages must apply to all employees across the board, unless there's a collective bargaining agreement that dictates how that's going to be done. And if an employer changes its decision about whether or not to make those deductions, the employer must provide written notice to all employees at least 7 days prior to the employee's first affected paycheck. So notice to employees is super important. And additionally, employers who deduct the employee share of the premium from wages must make the deductions from employees' regularly scheduled paychecks, except that the employee and the employer can mutually agree to less frequent deductions as long as the agreement is voluntary and memorialized in writing. So it's very important. It's got to be very voluntary and set forth in writing. Should be set forth in writing and signed by the employee. And deductions may not be made less frequently than quarterly, even if the employer and the employee agree on that. No less frequently than quarterly. And finally, employers must include in the employee's pay statement that a premium deduction for paid family medical leave has been deducted from the employee's wages. So you want to make sure that there's a notation on the pay statement so that employees know where that money is going. Employers are responsible for collecting employee contributions beginning on January 1 of 2025 and remitting those contributions to the PFML fund. I keep saying PFML fund quarterly. So now's the time to be thinking about registering on the DOL's web portal, although I don't think it's open until the beginning of the year, but be prepared to do that. And hopefully it doesn't crash when everybody jumps on all at the same time. But I'm sure that there will be, exceptions if that happens. The penalty for an employer failing to pay all or part of the contributions and to submit the wage reports is 1% of the employer's total quarterly main payroll. So that can be fairly significant. So you want to make sure that you're mindful of collecting and submitting those payments as due. Although there is a provision in the rules to say that if something is missed, notice will go out to the employer and they will have a period of time in which to correct what is most likely an oversight.
Mindy, do you mind if I give just a quick clarification about main
Go right
payroll
in.
and what main
Go right ahead.
employees mean for the program? Yeah, so just so everybody is on the same page, and the DOL has been very helpful with this in terms of explanation. In terms of people that are eligible for the plan, we are talking about main employees. And so that's why the quarterly main payroll is kind of stated as such. The example given is you're a company that's involved in multiple states. The 1% that you are going to be responsible for is just based on your main employees. So it's not your total 1% of your total payroll. It's just for the main employees that are represented for that. So I use the example all the time of my fiance is pretty much the only person in the state of Maine that works fully remotely in the state of Maine for a company based out of DC. That employer is going to have to be in the know about Maine's paid leave and still sign up as an employer because they have an employee in the state of Maine and they are subject to this benefit. So I just wanted to give that context a little bit just because it was brought up as the penalty being 1% of the main payroll. That's what we're talking about in terms of folks that are eligible for this benefit and main employees. Is there anything else you want to add to that, either Mindy or Ellen?
It just is an important point because a lot of employers have been asking precisely that question. To determine whether an employer has 15 or more employees, an employer must include all full-time and part-time employees on their payrolls during the relevant time period. And so this count is going to include both temporary and intermittent employees. So essentially everyone. And employers are responsible on October 1st of each year for calculating the number of employees on their payroll. So the determination will be made on an annual basis. Okay. Just quick slide here. Maine PFML applies to private sector employees and employers, regardless of whether or not they are subject to a collective bargaining agreement. So the collective bargaining agreement does not trump the requirements of the law. I get that question a lot too, so. You can go to the next one, yeah. So fraud. Unfortunately, the rules are, as currently written, have no real penalties for fraud other than sitting out for 1 year and the possibility of repaying benefits. And so, you know, I guess that depends on your perspective whether or not that's significant, but if somebody commits fraud, I would expect a greater penalty. And there's no indication that there will be any criminal referrals for insurance fraud. So it's limited to disqualification for 1 year and potentially the requirement that the benefits be repaid, but that's up to the DOL. And then I'm going to turn things back to Ellen.
Yes, so private plans. So a lot of employers will say, well, if I already have an insurance company, maybe that's providing STD to me or is administering FMLA or state leaves for me, can I have that same vendor go ahead and administer this for me? Do I have to go through the state program? And the answer is you do not have to go through the state program. However, you have to have an equivalent private plan in order to be exempted from the state program. That private plan can take on a couple of different processes or different approaches. One is if you're an employer who is really brave and gutsy and you think you can do this on your own, you can self-administer this on your own, pay those benefits, administer the claims when they come in. But if you want to do that, you do need a surety bond because you need to ensure the state that you will be able to pay those claims. However, that plan does need to be a substantially similar plan. And we'll talk about in a minute what is not a substantially similar plan. But I've talked to some really large employers who they're going to do this themselves. They're going to self-administer, they're going to self-pay, provided that they have all of the right rules in place to have a substantially equivalent plan. However, what's more common if you want to do this again is to tap into those insurance companies, carriers who are in this space, who will be offering private plans. Those private plans, they will take over the administration of this for you, the payment to your employees. They can do that either with a self-insured or fully insured insurance contract, but those contracts have to be approved by the State Department of Insurance and the state here. So it's not as easy as just saying, I have an STD contract, I'm good, I'm opting out of this. You will not be able to do that, but there will be a way that you can have your own private plan. When you have a private plan, that means you do not have to send contributions to the state. You can still take employee contributions and use them to help fund the premium that private plan administrator will charge you. But in order to be able to have that private plan exemption, your plan has to be substantially equivalent to what your employees would have received if you went through the state program. And what substantially equivalent really means is it has to be at least as generous, or if not more generous, than what your employee would have received through the state. So I won't read all of those different components there, but what's really important is all of the same types of leave have to be covered. The final regs say all of the same family members have to be eligible family members. The plan has to provide for the same types of appeal rights and same way the employee can take leave, those kinds of things. But one interesting thing is Maine is, I believe, one of the only PFML programs in the country that says you can provide 10 weeks of leave instead of the 12 that the employee would receive through the state in a private plan. However, be cautious. The way I read the rules is those 10 weeks have to provide the same total monetary benefit that the employee would have received if they went through the state program. So work with a carrier if you're looking to do that, or work with your in-house counsel to understand if you would like to offer 10 weeks as a private plan, because you're still going to be spending the same amount of money, if you will. The DOL will approve these plans for a 3-year period of time. There's a formal procedure for getting a plan renewed that you can look up. But the DOL also has the ability to withdraw the plan. Primarily, they withdraw plans if you're not filing your reports, or if you're not paying those claims appropriately or giving employees those rights. Applications for private plans cannot start until April 1st, 2025. Those of you who have been paying attention know that contributions start on January 1, 2025. So what does that mean for you if you intend to file for a private plan? It means that you do have to go ahead and submit those contributions for the first quarter of 2025. Warning, you will not get them refunded from the state, even if you have a private plan approved in April of 2025. So you can't be sitting back thinking, I'm getting a private plan. I know I am. I do it in other states, or that's my plan for Maine. So I don't have to send any contributions on 1/1/25. You actually do for that first quarter of the program. So just be careful, pay attention to that if your intention is to get a private plan. So if we move to the next slide, we'll talk a little bit about, we've talked about what is a private plan, what will not be. The question I get asked every day from folks is, I have an STD plan, I'm good. I do not have to comply with Maine PFML, right? And the answer is no, that an STD plan in and of itself will not be enough, because you have to cover all of the other leave reasons under Maine PFML as well. And there are also some additional things that have to be in your medical plan, like the reconsideration period, the right to appeal, some other provisions that have to be in there. So that is not going to be enough. What is also not going to be enough, any benefits you provide where you have discretion as the employer to stop the program, or benefits that need to be accrued over time, like PTO, that does not provide full coverage of benefits. So it needs to really be a formal private plan. You'll get a contract if you're going through an insurance company that's been approved, but it has to be more than just your regular programs that you're providing to your employee. And the state will look at your contract and will decide whether to approve that private plan or not. So not as simple as a lot of folks may think going in. So let's talk about now benefit formula. So we've talked about the fact that a lot of employees will be getting job protected leave for the time they're out on PFML. But if we turn to the next slide, they're also going to be getting income replacement. And this is really important, because what we find historically is, even when employees are entitled to job protected leave, either through state or federal law, a lot of employees can't afford to take that leave. So employers sometimes see employees not taking advantage of the job protected leave that they have. But when you add income protection to the ability to take that leave, we see more employees taking advantage of leave because they can afford to stay out. They don't have to make those tough decisions anymore of coming to work when they really need to be home, or they really need to be taking care of themselves. So the formula in Maine, it's slightly a little bit complicated, but really the intention of this is to go ahead and replace income based on a sliding scale in relation to the state average weekly wage. For those of you who aren't familiar, the state average weekly wage is released in July of every year. It's based on wages earned in the state in the prior year, and it tells you on average, what did folks in Maine make last year? And so what Maine has done here is they've done these percentages based on what is an average weekly wage in the state of Maine. So for employees whose earnings are either equal to or less than 50% of the Maine state average weekly wage, their wage replacement benefit will be 90% of those wages. For employees who make more than that, so they make more than 50% of the state average weekly wage, they will receive an additional 66% of the wages above that amount, subject to an overall cap or maximum benefit. The maximum benefit in Maine will always be the state average weekly wage. So no matter how high of a wage earner you may have, they're going to be capped at the state average weekly wage when we apply this formula to their wages. Currently, the state average weekly wage, you can see it there, is a little over $1,144 a week. So again, that will be the maximum anyone is going to be able to receive. And that should change, that will change every year. It typically goes up every year. So that amount will go up as wages increase across the state, as inflation kicks in, those kinds of things. One thing that's really important in the final wages that they clarified is the state average weekly wage that was in place on July 1, either when the employee applied for leave or when their leave started, whichever date is earlier, is going to be the state average weekly wage that applies to that claim through the end of the benefit year. So state average weekly wage goes up and I'm already on leave and I'm in my benefit year. My benefits will not be increased. They will stay the same through the end of that benefit year. So on the next slide, we'll talk a little bit about how are benefits paid, how does that work? If you're going through, and there are a few questions in the chat on this, if you're going through the state program, the state will determine what the benefits are. Just like the state will determine whether someone has a serious health condition. The medical certification forms will go to the state. Employers will not have to make these decisions if they're going through the state program. The state will decide what the benefits are for you. If you have a private plan, your vendor will decide what is a serious health condition, whether the employee has one, and what those benefits are. And so benefits here in Maine, they will be reduced if an employee is receiving other sources of income, like unemployment or workers' comp. There's some benefits there that I'm showing you that will not reduce the benefits the employee receives. And importantly, if you have an employee who works for more than one job, the benefits they receive from the state will not be reduced by any wages they're receiving from that second job, as long as they're not on leave under PFML for that job. So if you think about it, you could have employees with multiple jobs working for one, taking leave from you, and getting their full benefits from PFML for that time period that they're working from you. Benefits will be paid either by direct deposit or debit cards. Employees will have the option of what to do there. So if we move to the next slide, we'll talk about a little bit more about state average weekly wage. I talked about this concept briefly. We know it's going to be set on July 1 based on those wages earned in the state in the prior year. Right now, that rate is, I mentioned this, it's about $14.45 per week. That averages out to about $60,000 a year. And that is an increase from 2023. Typically, state average weekly wage does increase every year, but I have seen in other states, sometimes it stays flat and it stays static. That is the cap of benefits, but it also is used to determine those other attributes of the plan that I've already talked about. With regard to where Maine lands in the United States for state average weekly wage, when we look at what is the state average weekly wage in other states, Maine ends up at 29th on the list. Massachusetts is top of the list there. Mississippi, unfortunately for folks in Mississippi, is at the bottom of the list there. You can see there too, the Maine average weekly wage has increased pretty substantially over the last 4 or 5 years. And it's almost a 30% increase over that period of time. So if we turn to the next slide here, I just want to finish up at least with some requirements for posting. So Maine has a few different posting requirements in the statute that employers need to be aware of. Here on the screen is a poster that the state actually drafted for us and put out, which is really helpful. This poster, you have to take care of this in a number of ways. One is you have to post it in conspicuous locations in your workforce. So wherever you're posting your required employer notices now, you want to post here. If you have physical offices, you want to put it up in that break room. You want to put it on your intranet, but you also need to provide it to your employees. I'm recommending to my clients that they provide this before January 1, 2025. to their employees. It's not a mandate. Folks who listened to the state webinar yesterday probably heard them say it is recommended, though, particularly before contributions start, so employees can get an understanding of that. So you want to post it, you want to give it directly to your employees, I think at least before the first of the year. But you also need to give this to any new employee you hire within 30 days of their hire. So add this to your onboarding ritual. Make sure you're sending this to your main employees as they get hired. And again, at least in my opinion, you really want to send this to your employees before you start taking any money out of their paycheck to fund the program. So I'm going to turn it back over to Mindy to do a quick recap slide, and then we'll turn it over to Jake and Jeff. Oh, I guess we don't have our recap.
There we are.
Not there. Oh, there we go.
Yeah.
Yeah, sorry, that was all on me. Hand up there.
This is just a broad overview of what we've covered. But so all employers need to start preparing to register with the Maine DOL to determine liability for PFML contributions, to submit quarterly contribution reports, and to make required premium payments. And if an employer is not going to cover the employee's portion of the contributions, then that needs to be communicated to employees immediately. There are only 2 weeks, few weeks left before employees will begin seeing deductions from their paycheck. So you really need to let them know right away that that's going to be happening if you haven't done so already. And so we'll be answering questions shortly, but before that, Jake is going to take things back over, and so you can continue to put your questions in the chat, and we'll get to those after Jake and Jeff do their presentation. But before we move on, I meant to give a shout out to Steve Silver, who was very involved in putting the slides together. So I just want to give a shout out to him. Steve Silver is a lawyer in our office. So I don't want to take credit for his work. So
and Mindy, can I just give quickly, sorry, Jake, one more shout out. Steve wrote this amazing summary of the law. If you haven't seen it, it's called a Littler ASAP. You can find it on our website. This could be your Bible. Print it out or keep it, use it. It's really in depth. Mindy and I get co-credit, but we really just looked at it and made a few minor tweaks. It was really Steve's work, but it is the best summary of Maine PFML, at least I've seen from external sources, of really deep dive into everything you need to know. So another great resource for you, and another shout out to Steve.
Yeah, and when we turn back to the questions, I want to emphasize the fact that Ellen is a national paid family medical leave expert. She's been doing this for many, many years, so she's familiar with the paid leave programs in all of the other states. So she is not new to this, even though the rest of us are, because we're just coming to this now that that Maine has passed this law, but Ellen has been dealing with these laws for many years throughout the country. So we're going to be relying on her heavily.
Awesome. Thank you both. Before I turn it over to Jeff from Paper Trails, I do want to bring up one thing in regards to the private plan opt-in, and just the importance of the timing of when you do that based on the rolling quarters, and what the difference is between the first 2 months of a quarter and applying in the last month of a quarter. Ellen, do you want to talk on that, or you want me to?
Either way, happy to, or you go right ahead there.
I'll give it a stab, and you can correct me when I'm wrong.
Sure.
So when you start being able to opt into a private plan starting April 1st of this coming year, the Department of Labor has said and states in rule that if you apply to the private plan within the first 2 months of a quarter, so for that example being April or May of 2025, it is assumed that during that time frame, the department will be getting that application and being able to square away that private plan for an employer within that time frame before that quarter is over. That means that if you do that private plan application within those first 2 months of the quarter, you are not expected to contribute to the fund for that quarter. If you end up doing an application in the last month of a quarter, so for this example being June, it is not expected that the application will be done in time and that you will be approved for that private plan. So an employer will be expected to pay the contributions for that quarter of April, May, June. These applications are done on a rolling quarter application basis until benefits start. So whether that's April, May, June, July, August, September, October, November, December, those first 2 months are really important from an employer perspective if you do not want to pay into the state fund for that quarter that you are going to be applying. Anything you want to add with that to that, Ellen?
No, that was perfect.
Okay, I just want to make sure that was brought up because if you do apply in a specific quarter and it ends up being that last month and you say, hey, whoa, I'm opting out of this plan, I shouldn't have to pay for this. There are regulations and guidelines from the DOL about that specifically to be brought up for that scenario. So if you are planning on going to a private plan, and you do not want to be giving contributions for that quarter that you are doing that application, do so in the first 2 months of the quarter. So with that, I'm going to stop sharing my screen and invite Jeff Burnham from Paper Trails. Paper Trails is a payroll and HR servicing company out of Kennebunk. And Jeff is the VP of sales. They are a member here at the chamber, and they've been a great resource, both Jeff and Chris Clough down there in terms of kind of the employer HR perspective of what kind of employers needing to know on a granular level with this program. So Jeff, thank you very much for joining us, and I'll turn it over to you.
Thank you, Jake. Really happy to be here with everybody today. Just a quick couple of comments about Paper Trails. We're a Maine-based payroll service provider. We work with 1,000+ businesses here in Maine, and we've really tried to get as much information out to our clients and kind of out globally in Maine about this program and the impacts to businesses and the steps they need to take. So what I'd like to do is just kind of walk through kind of what those next steps are for businesses to ensure that you are taking the steps necessary to register and collect and remit those contributions. So we've come up with essentially 3 important steps to implement this to stay in compliance and to avoid any unnecessary penalties. As a reminder, as both Mindy and Ellen mentioned, failure to complete the steps necessary here will result in penalties from the state equal to 1% of your quarterly Maine wages. We also note here quarterly/annual because it is on a quarterly basis. So if you don't collect and remit for an entire year, you could be looking at 1% of your gross wages in Maine for an entire year. So keep that in mind. So step 1, and we've told all of our clients, and we're telling every business we talk to, do this right now. Tell your payroll provider how you'd like to manage these payroll contributions, how you want it set up. If you're required to do a 1% contribution, or are you required for the 0.5%? Do you want to split that? Is it going to be split, half from employer, half from employee? We are seeing employers that are taking on that full 1%, but many are splitting that as a 0.5% between both employee and employer if you have 15 or more employees. So talk to your payroll company right away and let them know how you want to have that managed. Step 2. Begin withholding on January 1st with that first payroll in January, and provide information to your employees about this program. Employees, they know how much is going to be coming in their check, and when that net take-home direct deposit or that live check is slightly lower, they have questions. So we put some resources on our website. We created a landing page, papertrails.com/PFML. we have some resources there for employers to share with their employees about the program and about what will be collected from them through their payroll. The ever important labor law poster, that PFML labor law poster, get that out there, get that in front of your employees. Also, please be sure to update your employee handbooks, any policies, any handbooks, and as Mindy and Alan mentioned, that new employee onboarding journey, make sure this information is in there. Make sure your new hires are aware of this. Step 3, and this is one that needs to be done in January. When the state opens up the portal, register your business. For us, we're saying we deal with a lot of mom and pop businesses, and they're doing a little bit of everything, and we're recommending to them, hop on the website, register yourself. If you don't have an HR department, you don't have a finance department, you're going to have to take this on yourself to make that registration. And then also, once the business is registered, you can assign delegates within there to perform certain tasks. Things that payroll providers really need to do, and this is just kind of the best practice things that we're looking for, is withhold the payroll deduction starting January 1st based on the business's preferences. Submit the wage reports in a timely manner for you every quarter. Remit those payments on time as well so that there are no penalties. Help determine what that employee count is every year. Again, there's a measurement period, there's a measurement date, and to make sure that those are done correctly. And business owners, check with your payroll provider to make sure that they can do all of these things for you. We've been working feverishly, within the platform we utilize to make sure that we have the necessary reporting there for our employees, or our clients, making sure that we have, that we can do the calculations for them and communicating with them to make sure that they are aware and that they understand what this all means to them. And lastly, from a resource perspective, we do have a landing page, papertrails.com/PFML. We have information on the program, employee information sheets, and links to other information that we've put out there as well for our clients and others so that they understand the program and know what their next steps need to be.
Thank you, Jeff. I really appreciate that quick rundown from kind of that HR payroll service company perspective. I know there's been a lot of questions to the DOL as well about the FEIN numbers and how that correlates to how you should be setting up in the portal and what that kind of means for various different types of employers. I know there has been guidance from the DOL that in terms of the amount of times and the designation a business needs to set up in the portal as an employer is really dependent on that FEIN number that is designated. So if you have a lot of different branches under one kind of main hub employer, it really goes by that FEIN number. And if there are multiple associated with that under a big umbrella, each FEIN number needs to register for that employer portal separately, because that is the designation that the DOL is going by. So just from a practical sense of when that portal opens up in January from the DOL, that's something just very important to remember if you're in that situation. Is there anything that you want to add on that regard, Jeff, in terms of kind of the nuance there?
No, I think you did a great job, Jake. Thanks.
Awesome. I will be turning over to the chat now and kind of sifting through these questions for Mindy, Ellen, and Jeff, whoever wants to chip in here.
And
let's start with who
for
educates employees on this benefit, all the pieces that must be included in the written notice, i.e. an ambivalent employee who states that they will be out but not why, etc.
Yeah, and I think Mindy tag teamed me in here for the I think she was I got the sense that I was tagged in, so I will start, but please anyone else, I don't want to hog these questions, although I'm a total nerd in this area, so you will have to push me aside if anyone else wants to answer, but please feel free to. I think this really comes down to that notice we showed at the end, right? And so that's the entire purpose why employers have to post that notice and give it to employees, is so that they know what their rights are under the law. And I think also Jeff had a great suggestion. I'm a big fan of putting a PFML policy in your handbook, not just the poster, but really giving your employees details on how they need to comply, what the benefits are, so that there is no way that employee can say later, oh, I didn't know, right? So the poster is the way you do this, and this is an employer responsibility. Handbook policies are, in my view, a best practice. Make sure you're sharing so the employees can't say they didn't know later.
Awesome, thank you. Next question is, so employees could possibly go on leave twice a year. I think that was covered, especially with the stipulations between intermittent leave and what leave can be taken for. Obviously, the breakdown there is pretty stark in terms of what leave can be taken for and the intermittent basis that it could be taken for. So I think that that was covered pretty
Yeah,
extensively.
can I just
Yeah, go
mention
for it.
one thing on that? Because if folks are new to these PFML plans, the benefit year is probably a new concept to them, and I want to reiterate
Yeah.
that, right? So the benefit year is going to start the Sunday before the employee takes leave for any reason. And that benefit year is going to continue to apply for any leave taken within that 52-week period, rolling forward from the Sunday before leave starts. In that period, you only can take 12 weeks of leave, no matter how many different kinds of leave you take, right? Once you get past that 12-month period, you get a new entitlement of time and you will be able to take more time. But within that, this is why the benefit year is so important in the PFML context is, yes, you can take it more than once, but you're going to have that 12-week cap if you are still within that benefit year.
Yeah, thank you for that clarification. Next three questions I'm going to kind of group together here in terms of kind of gray areas within confidentiality and documentation for leave, especially around medical leave. So how can employers kind of navigate that in terms of too much information about personalized conflict with other labor laws on what can be asked by an employer in terms of leave? And any type of documentation confirming diagnosis, or are employers just going to have to accept like a text message or something like that and kind of take their word for it?
And this is why it's important to understand that the state or your private plan will actually be administering these claims for you, unless you self-administer on your own, which I think is going to be rare in Maine. That information is going to the state or your private plan. That confidential information does not and hopefully will not be shared with you, the employer. The employee does have to tell you they need to be out, why they need to be out, in the expected frequency and duration, but they do not have to give you a diagnosis or any more specific information. They will provide that to the state, and the state is not going to provide it to you. They're going to tell you your employee filed for leave. They're going to tell you the leave reason holistically and the frequency and duration, but they will not share a med cert with you as the employer. And you really want to counsel your employees that you don't want this information. You don't want specific details on what someone's diagnosis is or condition. You do want to know if it's a medical leave versus a family leave, that's okay. But you should not be getting this information, and you won't get it from the state. Now, if your employee signs an authorization with the state can share more information with you, but I suspect a lot of employees will not. So here it's a little different from when you're administering Maine FMLA or FMLA for yourself, where you're getting the med cert and you're getting this information. It's not going to happen. What the employee has to do is send you written notice that they need leave and all of the elements of that Mindy talked about. I need leave for X number of days. I need it. The duration and the frequency will be this. They do not have to give you this specific medical information, nor do you want it, honestly, as an employer.
Awesome. Kind of in the same realm, in terms of reason for taking leave. Who obviously the definition of serious medical condition to some people can be a very subjective thing or a sliding scale. Is there a specific list of covered medical conditions that do apply as a serious medical condition? And how should a business owner kind of navigate this in relation specifically to HIPAA?
Right. And so great questions all around. Again, if you're going through a private plan or the state, they will determine whether a serious health condition exists. You do not determine that as the employer. But when it comes to how serious health condition is defined in Maine, as I mentioned earlier, it's a little different from FMLA, but basically the conditions that are included are it's an injury, illness, or impairment, including pregnancy, including physical and mental impairments that either includes an overnight stay in the hospital or what we call continuing treatment. Continuing treatment is not specifically defined under the sorry, I keep saying Mass because that my brain is in Massachusetts, sorry, under the Maine PFML, but I believe they'll look to the FMLA definition, which really means more than 3 days of incapacity, plus seeing a doctor within a certain amount of time and seeing the doctor enough times. And so specific definitions, you don't have to worry about that. The state or whoever's deciding this for you is going to worry about that. And with regard to HIPAA, one interesting thing to note is HIPAA does not apply to an employer when they are administering leaves for their employees. It applies to healthcare providers who provide information to third parties. But FMLA, ADA, Maine PFML do have confidentiality provisions that require an employer to keep any medical information they have confidential and only share it with people who have a right to know. So a little bit of a nuance, not really, doesn't really change the outcome, but if you do get medical information, make sure you're keeping that confidential in a separate medical file from a personnel file, and don't share that with anyone who doesn't have a business need to know.
And can I raise a question / concern, and Ellen can answer this? Is that so if an employee raises an issue about a need for leave and doesn't say I want paid family medical leave and just says they need a leave for something that might be a serious health condition, how's an employer to know that they're asking for paid family medical leave versus family medical leave, because there are different standards and a different entity is going to be administering the programs?
Right. I would say best practice in Maine doesn't specifically require this like other states do, but I think a best practice is you then give the employee or point them to where that notice, the poster is on your intranet, and say, Maine does have a program. Take a look at this poster. If you do believe that your reason is covered, please go ahead and file. You also always want to evaluate any unpaid state leave laws that may apply, including FMLA and Maine FMLA, because under those statutes, the employer is obligated to go ahead and evaluate leave under those laws whenever the employee either asks for it or gives enough information for the employer to know they might need leave under FMLA or Maine FMLA. So I think your best option is to, again, inform them of their rights under Maine, tell them how they file, and then obviously evaluate whether those leaves are covered under the leaves you are administering, meaning FMLA if you're large enough, and Maine FMLA, which remember is only a 15 employee threshold. So most employers are covered under Maine FMLA, even if they're, they're not 50 employees, they're still covered under Maine.
And so one more follow-up question. So if the employee is looking for paid family medical leave and you have all this information, would you go ahead and designate it as family medical leave as well?
Under FMLA, absolutely. Absolutely, because once an employer has information to suggest that an absence is qualifying under FMLA, they have a duty to send certain notices within 5 days. One, an eligibility notice, whether you're eligible under FMLA, and a rights and responsibilities notice. And if they have enough information to know the absence is qualifying, they have to send a designation notice. So you absolutely want to go ahead and process under FMLA or Maine, or both. If you have 50 employees and the reason is covered under both, go ahead and do all that for both. Because if an employer doesn't do that, the employee can turn around later and say, you didn't give me the protections of the laws that I had available to me.
And we didn't
Nick,
practice it, but I'm concerned about these competing leave laws that people may overlook and just step in it inadvertently. So you've got to be thinking about all of the various leave laws at the same time.
Exactly. Mm-hmm.
Awesome. Thank you for that, Mindy, and the explanations, Ellen. These two I'm just going to kind of quickly bang out here just for the sake of time. Are part-time employees also eligible for this benefit? Short answer is yes. It all has to do with that wage threshold. There is no exemptions or stipulations for types of employees. It's all based on that wage threshold, which was a certain multiplier for the state's average weekly wage over a period of time, but they slimmed that down to pretty much the stipulations for unemployment. They've linked that statute. So short answer to the part-time employee question is yes. And then are employees allowed to exempt themselves from this tax, like in the state of Washington? That answer is no. Employees are not allowed to exempt themselves. And I will note just with that quickly, employees can also not choose to stay with the state plan if an employer decides to go with a private plan. The employees go with where the employer goes, and it's kind of treated in totality as one unit, not what employers are doing and what employees are doing. So that's whatever conversations an employer needs to have with employees about that. Not that there's really a terrible amount of say, but because of substantially equivalent plans. But again, the answer to that is no, employees cannot opt out. In terms of collective bargaining agreements, does it need to be bargained for private companies? Obviously, there are stipulations between public and private in terms of collective bargaining agreements. But for private companies, does it need to be bargained for?
I would suspect so.
Oh, I was going to say, I'm not a labor lawyer, right? But so take that with a grain of salt. But either way, you have to provide these benefits, right, for private companies. So unlike some other states, there is no exemption for private CBAs. So even if your CBA does not allow for this, you have to provide it. Whether you have to go ahead and bargain to give employees the rights under the state law, Mindy, I'll defer to you if you do labor work. I do not.
But I don't think that was her question. I think it was the split between who's paying for it, not whether or not they get it. Unless I misread that.
For my interpretation, in terms of who is paying for what, I think the conversation is obviously open to happen about what percentage an employer is going to cover up to that 0.5% for employees. So I don't think there's really any barrier from those conversations to happen when those contract negotiations start. But that'll come down to the specific conversations that you have within that collective bargaining agreement and those kind of negotiations that are going to be happening. So I think the answer to that is it's going to be varied from company to company. Have you seen any guidance on how the state will calculate the amount of the required surety bond? The comments only show that the department will calculate the amount.
That's all I've seen as well. Even if folks haven't looked yet, there's also a document out there that's really helpful. It's 124 pages though, so fair warning. Where the state, I call it a preamble, but others probably call it something different, where the state goes through every comment they received and their responses to them. In that they provide a little more information and basically say it will be determined on a case-by-case basis based on a variety of factors. And I think, that variety of factors probably is number of employees, number of claims anticipated, those kinds of things. But I haven't seen anything more specific. Other states, for those of you who are familiar with this, there's a very set formula. If you have X number of employees, your surety bond is Y. Maine, I believe it looks to me from that preamble that they're going to do this on a case-by-case basis. And they have not, at least as I've seen, shared the formula they will be using for that.
Thank you. Next, as I'm scrolling through here, um, more just kind of comments than anything. How can an employee be on leave from one employer and not another? Because that's the way the statute and rules were written. Um, so maybe we can leave the commentary to that there. How will this impact H2A and H2B workers? I think that kind of speaks to that wage threshold in terms of
Mhm.
eligibility that we talked about, because there's no other um, guardrails or stipulations about exemption of different types of employees. So really to answer that, it's really dependent on that wage level that folks are going to be eligible for this plan or not. Um, already
And
answered. Oh,
it
go ahead.
was, you missed a question up at the top. Well, not depends on where you're looking, but it says applications for exemption open on 4/1/25. Depending on how long approval takes, will employees have to continue to pay the tax until approved? And the answer is yes, but they may get, and it's a premium, a contribution, but once it's approved, they will get the premium back.
Yeah, I think that kind of
My
speaks to
reading.
also that time frame of when that private plan application happens, whether it's in that first 2 months of the quarter or that third month of whether or not they're going to be responsible for that quarter of remittance or not into the state program. Um, but another thing to just note, and I think it was Ellen that mentioned it along the way. At this point, the assumption is any money that you put into the state program, you will not be getting back in any type of reimbursement or back pay or anything like that. So do not expect any money to be that is put in, regardless of private plan status or what you did during those first 3 months coming up here in 2025. You will. The assumption is you will not be getting that money back for any reason whatsoever.
But the question had to do with repayment to employees, and there is a provision about refunding that money to employees for, it looks like, the period of time that she's asking about. So that there is a provision in the rules about that.
Gotcha. No, thank you for that clarification, Mindy. Um, just winding down here. Can an employer force an employee to use their PTO before kicking in PFML?
No, they cannot. That's clear in the statute. So the other thing we didn't talk about is there's actually a 1 week, 7 day unpaid waiting period before medical leave benefits kick in, and it's medical leave only. Employees have the right to use their paid time off during that unpaid period, but employers cannot say you have to exhaust your PTO before you can file for main PFML. The employees have the right to take the program. Employees are also allowed, if I believe my interpretation is, if the employer policy allows it, to take PTO while they're on main PFML to top up to 100% of their benefits. I do not believe employers are required to do that. There's nothing in the statute or rules that says that. But if the employer agrees, employees can take PTO during that waiting period, as well as during the time that they're receiving benefits to get them to 100% of their pay. But anything more than what would get them to 100% of the pay will be an offset from the benefits provided by the department.
Next question here. So the employee just says that they need leave and we have to approve. When will the employer know it was approved? So there are stipulations within the rule about certain time frame notifications happening, both from the DOL in terms of when a plan was submitted and if that plan was in turn accepted. So the rule kind of stipulates those time frames. One thing I will mention within this is in terms of an application for leave, there is a 90-day post leave start window that is in the rules that an employee has to submit an application for leave. So there could be scenarios where leave could start, notification of that leave starts, but the employee has 90 days to submit an application to the DOL for the leave. And one of the reasons that this is a really big concern for us here at the chamber is one of the biggest things that we have heard from employers is whether or not the employee absence um, specifications are really addressed within this law and rule. And one thing that an employer cannot get back, no matter what, from this is time from their employee. So this is why this 90-day post leave window for application, when you lump it in with the 120-day job protection, as well as the ability for employers to be able to apply for an undue hardship provision. These things all kind of work together to create this concern that we have about the employee absence part of this law. Is there anything that you want to add, Ellen, in terms of the notifications?
No, I think just what it seems like there's still some confusion. So maybe just quickly how the process works. The employee has to give the employer notice 30 days in advance of foreseeable leave before they take leave. And if there's an emergency, the 30 days is waived. The way the process works is I go to my employer and say, I'm going to need leave in 30 days. And we talk about what that schedule of leave will look like. I tell them what I think I need, and we have a conversation. If the employer thinks that that schedule creates an undue hardship, then we talk about maybe a different schedule. The employee then files the application formally with the state. That application says what kind of leave is needed, the medical reasons, all of the who's my equivalent family member, all of that goes to the state. If the employer finds undue hardship, they let the state know that. The state then evaluates everything together. They evaluate the employer's claim of undue hardship, and they either approve it or deny it, and they evaluate the claim, and then they approve the employee's request. So the employee still has to give the employer that 30-day notice, but they're actually filing with the state, who ultimately makes the decision to approve or deny the request. So I think that's a little unclear based on the questions we're getting, and just wanted to go ahead and clarify that piece of it, because the employer is involved, but the state is ultimately making the decision on whether things can go forward. And the other thing that's important about undue hardship, even if the employer claims undue hardship, the employee still gets to take leave. They just take leave on a different schedule that they agree with the employer. So really important to note, you can't just say no and the employee doesn't get to take leave. They will still take leave. They just may take it on a different schedule than what they originally asked you for as an employer.
That explanation is much more eloquent than I, so I appreciate that clarification, Ellen. So just finishing up here, as we are getting to the bottom of the hour. Can an employer require the employee to continue to pay benefit premiums while they are out?
They can. So it's the standard for benefits is you maintain benefits, meaning whatever the employee had before they go out, they get to keep, but they also can be required to pay their share of premium. So that's, for those of you who are FMLA covered, that's exactly the same standard as FMLA.
Does sending the notice out via email satisfy the obligation of providing every employee that information?
I believe it does. It's not specifically mentioned in the regs or the guidance, but I think it does. There's nothing that says it has to be hard copy or it has to be mailed to someone. One of the things we're discovering in other states is try to be careful about having a proof or a trail that you sent these things out when you need to, because there may be audits. I don't know this, but there may be audits later to make sure those notices were given. And the other important thing is, if you don't give the notice, you cannot hold the employer responsible for giving you 30 days notice before they need leave. So those notices are really important. And you're going to want to have, if you send by email, for instance, some way of showing that you actually did send it. So just think about that if you do use email as the method of communicating that notice.
And I think too that the in terms of posting the poster, the DOL has been pretty clear that that posting of the poster is meets the requirement on their end for what that notification is. So just as a
Mhm.
as a practical
Yeah.
reminder there.
I would say though, except for the new notice for a new hire, I believe you have to give that to
Yes.
them directly within 30 days of hire.
Yes, absolutely. Thank you for that
Mhm.
clarification. Just quickly scrolling through the chat, I think we have hit on all of the questions asked in some way, shape, or fashion. Obviously, like with anything, if you have any questions, please feel free to reach out to me. My email, jlachance@mainchamber.org. More than happy to forward any of the questions or give any of the pass alongs to Mindy and Ellen to answer them for me. So please do please do that. I want to thank Ellen, Mindy, and Jeff for hopping on this morning. They've been a tremendous asset to myself and the chamber kind of throughout this process, and it's been really it's been I feel very fortunate to have them in our corner in terms of getting this information out. So thank you all, and be sure to be on the lookout for more information from the chamber as things go along. And be sure to check out the Maine Department of Labor's website for any and all uh, employer resources that they have, as well as a lot of different outlines for the poster and different FAQs and stuff like that. So please be sure to check those things out. And I hope everyone has a great weekend and upcoming holiday season.
Thank you.
Thank you.